Hello, everybody. Welcome. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on breaking down the ruling in Facebook v. I don't know if it's Duguid, Duguid. I've heard it a bunch of different ways. So however it's pronounced, I apologize if I'm butchering it, but everyone just knows it as the Facebook ruling. The Supreme Court has issued its ruling in the Facebook case and narrowed the interpretation of an automated telephone dialing system under the Telephone Consumer Protection Act. What does that mean for the arm industry? Today, we have David Kaminsky from Carlson & Messer here to offer his assessments of the impact and advice about how companies should react to this decision. I also want to thank TCN for being a sponsor of today's webinar. You'll get the chance to hear more about them a little later in our program. I don't want to take too much time before I get to David, so I'm going to forego my usual spiel about what's going on at accountsrecovery.net, except to tell you that I'm going to put a link in the chat box now. If you haven't joined the Slack channel, I encourage you to do it soon. Do it now. Click on it. It's free. You'll definitely get something out of it, and I promise. So let me tell you a little bit about today's speaker. David Kaminsky is the chair of the financial services law practice at Carlson & Messer in Los Angeles. He represents debt collectors, banks, other creditors, and asset buyers in the defense of all claims brought under federal and state consumer protection and related statutes. He manages a nationwide litigation for numerous financial institutions, and he has helped shape the law affecting the rights of creditors in the accounts receivable management industry throughout the United States. David provides compliance and training advice and develops policies and procedures for the arm industry. He was an ACA International Fellow Award recipient, the ACA International Attorney of the Year, chair of the Attorneys Division of ACA International, and is an award-winning attorney who has received accolades by numerous financial services trade organizations throughout the United States, and I really like him. So got that going for him too. The format for this webinar is going to be a conversation, but mostly just David talking about the ruling. We encourage everybody to submit questions, and we'll get to them as he proceeds through his discussion today. To submit a question, please enter it into the Q&A tab on your Zoom webinar control panel, or send it to us through the chat module. Since David's going to be talking a little bit about compliance today, let me indemnify him. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area and should never be used to replace the advice of your own legal counsel. David, we're 26 hours after the ruling has come out, so I'm sure you've got a lot on your mind. There's a lot that you've thought about already, so why don't you start talking about how we got here and what this means for the arm industry?
Well, thank you so much, Mike Gibb. Thank you so much, TCN. Thank you so much, McKay. Accounts Recovery, glad to be here and honored to do this. And look, this is just the tip of the iceberg, what we're going to be talking about today. There's so much to unpack. There's so many, let's say, future repercussions that this decision may have. So we're going to touch the surface here and hopefully give you a lot of things to think about and tell you where we are and where we may be going and what could happen in the future as a result of this decision. So really glad to be here and thank you so much for attending. First of all, let's just step back for 2 seconds. As you recall, several years ago, in a case called Duguid versus Facebook, Facebook challenged the Ninth Circuit Mark's decision with regard to what is the proper definition of an automatic telephone dialing system. As you recall, back in September 2018, yes, my birthday, unfortunately, that day, the Marks decision came down from the Ninth Circuit Court of Appeal, where the Ninth Circuit basically said that not only is an automatic telephone dialing system defined as that system which can dial numbers that are randomly and sequentially generated, but any system that can basically store and automatically dial constitutes an automatic telephone dialing system. That decision has recreated repercussions through the industry and many problems. There were many conflicts throughout the country with regard to the interpretation of what is an automatic telephone dialing system, as that phrase is defined in the TCPA. We had conflicts from various federal courts of appeal That conflict, a conflict created by various uh, federal courts of appeal, creates the firestorm that allows the Supreme Court to say, we have a problem here. We have federal court of appeals giving different interpretations of what is an auto dialer under the TCPA. We can't have that. Facebook has made a petition to the Supreme Court. Supreme Court says we have to take this decision and resolve this conflict. Just to step back, as you know, in the TCPA itself, there is a definition of automatic telephone dialing system, and that definition is equipment that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial those numbers. I'll say that one more time. In the TCPA itself, the definition of an automatic telephone dialing system is equipment which has the capacity, that's an important word, to store or produce numbers to be called using a random and sequential number generator. And for years, we have argued, and I have throughout the country in class action litigation throughout the country, have argued that definition is clear and unambiguous. And if you read that in the context of the entire TCPA, they are clearly only talking about random and sequential number generation that has a storage capability and then automatically dials numbers, or uses the random and sequential generator to produce numbers and dial them. So here we come to the Supreme Court, and the Supreme Court held as follows with regard to its interpretation of that definition of an automatic telephone dialing system under the TCPA. Basically, it said this: an auto dialer, an automatic telephone dialing system, from now on I'll say ATDS, under the TCPA is a device that has the capacity to either store a telephone number using a random and sequential number generator, or to produce a telephone number using a random and sequential number generator. So that is fascinating. It's the first time really that the Supreme Court, of course, has touched this definition and said that as long as you have a system that can store a number using that random and sequential number generator and dial that number, or if that random and sequential number generator can produce numbers and then dial those numbers, you have an automatic telephone dialing system. You know, the court's decision is not very long. It's actually roughly, if you just look at the analysis itself, it's roughly 6.5 pages. Maybe that's one of the shortest decisions I've seen in years from the Supreme Court. But they said, look, this is all about statutory construction, and it's all about the plain language. And we're not going to manipulate, and we're not going to rip this language apart in 80 different ways and contort it to mean something it does not. We do have to look at the language in context. And when you look at it in context from what this statute says, it basically says what it says and means what it says. And as Justice Sotomayor said during the oral argument on this case, and for me, in a sense, that was everything. When I heard her say, isn't the problem here that this statute is out of date and doesn't cover technologies that are being used today to dial numbers and to make robocalls and to call people on their cell phones? That's when she said that, that struck me. And I said, it is game over. Facebook is going to win this case. Duguid is going to go down, and this is going to be a win for industry. And I predicted, as many of you may recall on my previous lecture after the Supreme Court hearing, I said this is going to be bold, but I believe this is going to be about an 8-1 decision, possibly 9-0 decision, and maybe on a great day for the plaintiffs, a 7-2 decision. Well, as you can see, this was a 9-0 decision. It was unanimous. No one was on the fence. And basically, they said this: look, the statutory context in which the TCPA's auto dialer definition exists basically confirms that equipment must use a random and sequential number generator. It's what the language says, right? They noted that Congress found that auto dialer technology was basically harmful because auto dialers can dial emergency lines, et cetera. They can tie up any kind of lines of any kind if numbers are sequentially and randomly dialed. So they said, if you look at that context, that protecting the public health, right? Stopping these random and sequential number generators, which literally dialed every number in the number lexicon, starting at 1111 all the way up to the nines. That means it dialed every single hospital, every single emergency line, every single healthcare police station. There was no discrimination. They said that is a threat to public health and we got to stop that. And that's exactly what happened. And they said, look, the bottom line is the plaintiff's interpretation in Facebook, the Duguid interpretation that follows Mark's, that's any equipment of any kind that basically stores and dials numbers. And that's not what this statute said. And it's not for the Supreme Court to rewrite a statute. That's Congress's job. The Supreme Court interprets the law. It does not write or rewrite the law. So,
David, I'm just going to interrupt for just 1 second. I'll give you a chance to catch your breath.
Sure.
What I'd like to do is just take a moment and give invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Thanks, Mike from Accounts Recovery, and especially David for making this discussion possible. This is something that's very important to the industry, and I think we'll continue to learn more as the days progress. But again, as Mike said, my name is McKay Bird. I am the Director of Marketing here at TCN, but TCN is a cost-effective call center solution for contact centers, collection agencies, and as well as thousands of businesses worldwide. TCN has continually stayed current with the TCPA and CFPB changes by introducing enhancements to our core platform, one of which is our TCN compliance suite that has built-in natural language processing that uses smart algorithms to build compliance rules naturally. Simply type in your rule in the TCN compliance manager and the natural language compliance engine will create an easy to understand rule. TCN is a global provider of this comprehensive cloud-based software, and our suite of compliance tools helps meet the requirements of the TCPA. Our core platform also features a holistic set of easy-to-use automated agent tools, advanced apps for omni-channel communications, workforce engagements, compliance and data management, integration and automation, intelligence and reporting and analytics, collaboration and accessibility tools, and the suite and platform continues from there. So regardless of your size, application, or location, TCN can provide a robust solution for your call center and collection agency. So I'd invite you to give us a call or visit our website at www.tcn.com for more information. Thanks, Mike.
Thank you, McKay, and thanks again to TCN for sponsoring today's webinar. I really appreciate their continued support. David, I'm sorry I cut you off. Was there more you wanted to share? We've got a lot of questions that have come in as well, so wanted to make sure you knew that too.
Sure. I do want to get to some of your questions. And look, I'm just going to try to give you everything at a high level here. And how do we think about this decision? Number one, let me just say right off the bat, this decision is fantastic. This is the ruling that we've been asking for. I've argued this interpretation of the ATDS for years, since I had one of the very first class action TCPA cases in the entire country back in late 2006. It was like, what is this? But even reading that statute for the first time, I was struck by, this requires random and sequential number generation. My client doesn't have that. But there went all of the courts out in left field interpreting that auto dialer definition so broadly. You had the FCC for what now? 10, 11, 12 years interpreting the auto dialer definition and contorting it in so many different ways and saying all predictive dialers are automatic telephone dialing systems. That is not what the Supreme Court said. They are not having that. And then you had the FCC saying, okay, well, even if you have an auto dialer, as long as you have some level of human intervention, which we're not going to tell you what that is, well, then maybe you don't have an auto dialer. And the Supreme Court is looking at that human intervention language from the FCC saying, what the heck is this? This doesn't make any sense. And we're not going to give that any credence of any kind. So human intervention right now is pretty much out the door. This was really a gut punch, in my view, to the FCC by the Supreme Court of the United States. They clearly were not buying anything that the FCC has said. So in short, though, what does this mean? Does this mean that, my gosh, it is just a free for all and just let those auto dialers just rip? Well, let's talk about with some of the, what can happen in the near future. I wouldn't be surprised based on this decision if all of a sudden your calls on your cell phone start blowing up, right? Because all the companies, whether they are marketing companies, telemarketing, or making informational calls, are going to be saying, hey, I'm not using an auto dialer. The TCPA basically only prohibits auto dialers. Yes, there are separate telemarketing consent rules. There are FCC rules. There's the telemarketing sales rule and then the FTC. Those are completely separate. There's the do not call rule and the do not call list. And those are separate rules, and that's independent and separate from the auto dialer law. But companies who are using their dialers could say all day, hey, I'm not using an auto dialer. I can just call, ipso facto. I don't have any problem whatsoever. I can just let that baby rip and make all my calls. But I want to sit here and just say, let's talk about this. And this is sort of a not so fast. Yes, in maybe the short term, that is something someone can do, but is that a wise decision? And what other things do we have to be thinking about as we go forward? Just remember that in the TCPA, they said, remember the definition, it says it's illegal to call any person that's a call that's not made to an emergency line. If you're making the call to a cell phone, right, via an automatic telephone dialing system, okay, well, we sort of won that part. I'm not using an auto dialer. My system isn't an auto dialer, or at least I think it's not, because I don't think it has that random and sequential number generation, but it also has that famous word in the TCPA. It's a two-letter word. It's or. It's illegal to call via an ATDS or via a pre-recorded or artificial voice call. So if you have an artificial or pre-recorded voice call, those calls are still prohibited. Why? They are not ATDS auto dialer dependent. That section of the statute, and it is not really disputed by almost any court throughout the United States, it's independent. It's a separate prescription in the TCPA. It's a separate prohibition. So if you're making pre-recorded voice calls or you're launching calls with a pre-recorded voice, such as those calls that said, hi, this call is for Thomas. If you are Thomas, please press 1. If you're not Thomas, whatever it says, or words to that effect, or just a pre-recorded voice automated message, and you're sending, let's say, what we used to do in the past, those message blasts. You need to have prior express consent to make those calls. So we're going to get into that in a minute and how important that is. Also, as you recall, that pre-recorded voice is not only just important generally, but as you saw in that December 2020 decision from the FCC, the parting gift, so to speak, thank you, Commissioner Pai, and I say that with major British understatement and tremendous sarcasm, where Commissioner Pai issued an FCC ruling that said, oh, remember how we excluded generally commercial calls that weren't advertisements, such as debt collection calls, that if you left pre-recorded messages on landlines, you were good to go. And the TCPA really gave an exemption for those calls and didn't prohibit those calls. Not anymore, at least temporarily, with regard to the December 2020 TCPA order. Very important to remember. The FCC said you can make 3 calls in a 30-day period that are pre-recorded voice calls to landlines, and you sort of have a free pass. But anything after that, you have to have prior express consent. So if you're leaving pre-recorded automated messages on a landline telephone, and you intend to leave more than 3 in a month, you need to have prior express consent to leave that pre-recorded message, or you are violating the TCPA. So that was a thank you parting gift from the FCC. No thank you. And the ACA International has recently, along with a coalition of the banking community, and has launched an attack on that. And hopefully that attack will be successful in asking the FCC to add certain language and to rewrite part of the order that they had just issued. We'll see about that. More to come on that. I can't get into that now. That would take up the whole session. So so this is just some of the issues to think about. Watch out for your pre-recorded messages. Yes, there's ringless voicemail out there. There's direct drop voicemail as well. Remember, we just have to tread cautiously with regard to that telephony. Those pieces of telephony are fantastic because they drop a voicemail right into the cell phone without making generally that cell phone ring. That's the point of it. They're dropping that pre-recorded message, or that message, whatever it may be, into the landline bucket of your cell phone carrier. So technically it's not going through the wireless services, but with caution, some courts have said, in our view, looking at it simply, those are pre-recorded message calls. So in order, if you're going to make them, you got to have prior express consent. This decision does not change whatever analysis you need to be doing with regard to whether you can and cannot make pre-recorded message calls without prior express consent. And I would consult your legal counsel heavily in that regard. So one of the biggest questions that I think you need to be thinking about right now is the first step. Does our telephony contain this random and sequential number generation capability that can either has a storage capability or can produce numbers and then have them automatically called? Okay, that's something to be seriously considered. I would be consulting your telephony provider and also your legal counsel to give you guidance in this regard. And I'd like to bring up something that I have mentioned in the past that sometimes I think people have given short shrift to, but I think it's something absolutely critical that people do not think about. And I stumbled upon this in a TCPA class action that I was doing in a very large multi-billion-dollar, at least potential TCPA risk class action years ago. And that was something called legacy software. This is software that exists in your telephony or your calling system or your dialing system, in your automated dialer, in your predictive dialer, whatever it may be, that had random and sequential number generation capability that a company was not even aware of, that was sitting within their system. Remember, under this Supreme Court decision, the word capacity is still alive and still means something. So the statute does say an automatic telephone dialing system is something that has the capacity to store numbers using a random and sequential number generator, or to produce numbers. So capacity is going to be an issue. I'm sure that the plaintiff's bar is looking at that word capacity. Again, it's not generally what you're doing literally at the moment, but that something that would have hopefully the present capacity, if that's the way that phrase will be interpreted, to randomly and sequentially generate numbers or to store numbers. So that's something that you need to be thinking about as you move forward. Please consult your telephony experts and ask them, do I have any legacy software within my own dialing system, or does the third-party telephony system that I have hired to make my calls have any kind of legacy software that could give the potential for random and sequential number generation capability or storage capability? Something to really think about that people, I think, weren't really concerned about when I was lecturing in the past. I said, what about that legacy software? I'm not too concerned with that. Well, I think you really need to be right now. And it could also extend to hardware as well. So everything needs to be examined from top to bottom.
Okay. Do you want to take a few questions now, or you?
Yes, Mike. And are they in the chat box?
Some of them are in the chat box. Some are in the Q&A. Some of them you've answered, I think, in some way, shape, or form. So, like the first question was, where is he here? Is capacity still an issue to be litigated? I think you addressed that just now. Does this new ruling mean that express consent is no longer required if the dialer does not meet the definition of an ATDS?
Okay, so let's talk about that. And I touched upon it with the pre-recorded voice call issue. So if you are making artificial or pre-recorded messages, or you intend to do so, or you intend to message blast, you still need to obtain consent to call someone. Okay, that's very important here. I think you also need to think about the issue of revocation of consent, because that's important, not so much from an auto dialer view. And let me just explain what I mean. If someone says to you, please don't ever call me anymore, and you say, guess what? I'm not using an auto dialer, so I can call them. What's the big deal? Well, that doesn't take into consideration the 50 other laws that I'm not mentioning right now that just may be applicable here. And that may, prevent you, of course, from calling someone after they said not to, whether that's the FDCPA, whether that's the Florida FCCPA, whether that's the California Rosenthal Act. I could go on and on about all the other states' consumer protection laws and laws that are similar to the FDCPA that prohibit you from calling or harassing any person after they've asked you not to do so. So you need to be very careful with that. Prior express consent was a phrase that was required if you are literally calling someone with an auto dialer. And also, let's just remember what the Supreme Court said here in this decision, that they said a text message is a call. They said, we're not going to really go down the road whether it is or isn't, but it doesn't seem that any party is fighting that issue. So we're just going to go along with it, that a text message is in fact a call. So it's treated the same way under the TCPA as if it were the same thing as a call. So therefore, if you are using a text platform, or if you're sending text messages, again, talk to your text message platform provider and have them dig very deep for you to make sure that their system does not use random and sequential number generation and doesn't have that capacity, whether they're literally using it at the moment or has the capacity, because capacity is the rabbit hole that a lot of plaintiffs' attorneys may go down. And that's where they may try to fight with some of this technology that could be borderline. There's a lot of plaintiffs' attorneys thinking that, you marry two systems together and one is a computer system, and part of that computer system can randomly and sequentially generate telephone numbers. Some aggressive plaintiff attorneys who have the wherewithal to spend the money will maybe go down that rabbit hole to fight that issue. They're thinking, okay, this decision does say you need to have random and sequential number generation or else you don't have a dialer. But we think that there's many systems out there that do have that capacity and that potential, and that people using those different systems know about it. I'm not going to be surprised if many of the telephony providers today, whoever they may be, will issue white papers, that falls in line with the the Supreme Court ruling, and says that our system does not contain random and sequential number generation capability, either to store or produce numbers, and it does not even have the capacity to do that in any regard. So I wouldn't be surprised if you do that, but that's part of your own due diligence in examining your own dialing systems.
On the topic of text messages, we've got a couple of questions. One is, isn't a text a form of pre-recorded message? And the other one is, the decision appears to assert that the text message, even auto-generated, does not constitute a pre-recorded or automated call. Do you think this is true?
Okay, so let's try to unpack both of those. Let's talk about the first question. Is you raised a question that's enormous in its scope, and would be a 20-minute lecture in itself. But let's talk about, is a text message a pre-recorded message? Very interesting. And is this one of the rabbit holes that some of the plaintiffs bar will try to go down? Because what they will say is, I'm going to look at a text message, the same thing as a pre-recorded message. It's already, quote, pre-populated, right? It has a set amount of words, right? And therefore, if I'm sending out blast text messages, why is not that the same as a pre-recorded message or an artificial voice call? Okay. I think actually that is somewhere where the plaintiff's bar may go, but I think that this would get back to plain language and probably looking at legislative history. Back in 1991, when the TCPA was issued, no one was thinking of a, quote, call as a text message. That was a creation by the thank you again, Ninth Circuit Court of Appeal, in the Satterfield case in 2009, I believe, where the Satterfield case said that a text message is a call, and just looking at the FCC rulings of the time and the TCPA, they meant to encompass within their fold a text message. So the plaintiff's going to say that, okay, since the text message is a call, and Satterfield says that, and other federal courts of appeal throughout the country have agreed with at least Satterfield in that regard, then if it is a call, what's the difference between that and a pre-recorded voice? Why isn't a blast text message no different than a blast pre-recorded voice? I don't think we're there yet. I think that a voice means something from the voice, something that is vocal, something that is a pre-recorded vocal recording. I don't think it's the same thing as letters in a text message. So I think that may be a rabbit hole that the plaintiff's bar does go down, but I don't think it has a favorable end to them. But it is an avenue that they could try to push. And I can see the arguments on both sides. I do believe that the defense here, we have the better argument just from plain language. And if it's any indication, the way the Supreme Court has ruled, I think federal district courts, the lower level federal courts, then the appellate system, the Federal Circuit Court of Appeals, I think that they will be constrained now to say, you know what, we have to do a plain language interpretation, and we have to do that in the context in which the TCPA was written, because the Supreme Court said, and Justice Alito really hit that hard in his concurring opinion, context is everything.
I think you've covered this, but we've got a couple of more questions that have come in on it, and that is, are messages such as "please hold for the next available representative" considered pre-recorded or artificial?
Fantastic question, and I get this in different times, and there are various forms of pre-recorded messages. Basically, we used to say a call is a call is a call. We used to say, right, in the FDCPA context, a dispute is a dispute is a dispute, anything that looks and smells like it. With regard to a pre-recorded or artificial voice message, if you are launching a call, right, and that's the first thing that let's say a consumer would hear that says, "Hi, this message is for Tommy Smith. If you're Tommy Smith, press 1. That is a pre-recorded voice call. It could be an artificial voice call, depending on how it's done and how it's configured. That is likely the launching of the making of a call via a pre-recorded message or an artificial voice call. So I think that's something that has to be seriously considered, would be generally prohibited unless you had prior express consent from the consumer to make that call. That's why I think that all of the brilliant, and I know there's more questions, but all of the brilliant and careful, let's say, risk mitigation that all of you companies have done over the years and have amped that up on such a high level, and your compliance level has hit a zenith like it never has in the world of what you do. I think that you have to be thinking, hey, you know, we have a compliance protocol in our company to ask the person, hey, is this the best number to reach you out? Is this at the number at which I could reach you at. Do we have permission to call you at this telephone number? Do we have consent to call you at this telephone number? Those two phrases right there. That's what you have been asking on phone calls. Some companies have a requirement that every time that they get a consumer on the phone, they say, hey, I'm seeing that I'm calling you at so-and-so number. Do I have consent or permission to call you at that number? Yes, you do. Remember what the FCC has said, and this has not been taken away yet. And it has been upheld by many, many courts, at least on the federal district court level. Many federal district courts, which is not binding law, have at least agreed that the mere obtaining, as the FCC has said since 1992 in its order, the mere obtaining of consent to call a number gives you the right to auto dial that number and leave those pre-recorded messages. So you can use your auto dialer and you can leave those pre-recorded messages so long as you have that consent, that someone says you have permission to call me at this number. That gives you auto dial rights, that gives you pre-recorded message rights. So think about that, think about continuing to follow those compliance protocols that you have in place, because why not? It can only help you. It can only help you and give you the right to then leave those pre-recorded messages, to make those landline calls, and to, quote, do those more than 3 a month if you need to or choose to do so. And that's the way your company needs to work and to operate properly, okay?
We have a question asking sort of seeking a workaround, and that is, can I simply hire an employee to say, please hold for the next available agent, to avoid the concept of a pre-recorded calls as long as it's done live?
Yes, if you're launching a live call, right, there's no proscription against a live call, right? So if you're making a live call using an auto dialer, yes, then if that call was launched via an auto dialer, as that is now defined by the TCPA, then you have to get prior express consent to make that call, even if it's a live call, okay? But if you're not using an auto dialer and you have done that analysis and you have vetted that issue thoroughly within your company, and you're not using that kind of telephony and you're using a live call, then of course you're not using a prohibited auto dialer under the TCPA, and the TCP says that, and you have to get consent if you are using an automatic telephone dialing system when making calls and leaving text messages. And the same, of course, with a pre-recorded message.
Okay, let's see here. I think we've gotten to most of the questions. If I haven't gotten to your question yet, I apologize. If you want to resend it, we're only going to go for about 5 or 10 more minutes here before we wrap up. So another question that has come in: would obtaining consent to call also apply to landlines for sending pre-recorded messages?
And I think I answered that earlier, but
okay,
because of the FCC's new rule with 3 and 30 days, or with the HIPAA calls, I think you have 3 per week, if I'm right, with the FCC new rule. But anything that exceeds that, you would have to then get prior express consent. So if you're going to limit your calling strategy to, let's just say, under a non-HIPAA related call, it's going to just be an informational call regarding a credit card debt. You're leaving pre-recorded messages on a landline phone. If you're staying within that 3, you can leave 3 pre-recorded messages, and they're saying you don't have to have prior express consent, but anything over that number you do. But because that's such a borderline issue, right, then why doesn't it make sense, of course, to keep up your strategy and just obtaining that consent? It's so easy for your representatives on the telephone to say, hi, do I have permission to call you at this number? And they'll say, hey, yeah, well, you're calling me on it. Okay, I got your permission. Great, good to go. And you're recording those calls so that you have the most important thing I always talk about: evidence to defend yourself in the event someone tries to hit you with a TCPA individual or class action. It is just the most wonderful tool to take your one piece of evidence, that recording, hand it over to the plaintiff's counsel through your attorney or otherwise, and say, hi, we had permission and consent to call your client to make this call. We weren't using an auto dialer, and okay, we did leave a pre-recorded message. Therefore, we had consent to do so. Game over, Mr. Plaintiff's Counsel. Please dismiss your case forthwith. So,
one thing I think you've touched on, but maybe we could spend a little, I don't know if there's worth spending a little bit of time on, but we do expect to see legislation from Congress on this. I know yesterday, Senator Edward Markey came out, issued a statement saying he was going to propose legislation to sort of address this situation. So whatever we're dealing with now, we may not be dealing with for very long. It seems, if Congress has its way.
let's talk about that for a minute. That's the big thing that we're all talking about right now. That look, temporarily, there is a terrific reprieve on what is an auto dialer under the TCPA. Could that be changed by a congressional act? As Senator Markey said from Massachusetts, it was clear when the TCPA was introduced that Congress wanted to ban dialing from a database. Well, that's his opinion. I think the Supreme Court disagreed. So he's furious about the decision because he says by narrowing it, you're insulting the public. And what some are saying is the auto dialing and now that they have used the moniker, unfortunately, even in the Supreme Court, the word robocalls, right? Everything today is a robocall, but that had such a bad moniker, and that's not true. Companies who are calling their consumers or their customers, right, for a payment purpose, right? They have the absolute right to do so. That's not a robocall. Robocall always had the bad scam telemarketing moniker that went along with it. Anyone who makes a call today with automatic technology is considered a robocaller, and somehow the Supreme Court bought into that. Even in the Barr case, when we had the Barr Supreme Court case and the hearing on that, and of course in the Duguid as well. But this just means that with what's happening, the plaintiff's bar absolutely has taken tremendous notice. It would be foolish to think otherwise. The National Consumer Law Center has, and so many different other groups, and so has Congress. So have the state's attorney generals. They're already talking about this decision. Many have anticipated it. Many of you may recall that back in May of 2020, or a couple months before, California, one of the legislatures there had proposed AB 3007, which was a revision to its auto dialing and announcing device law under the Public Utilities Code. And what they did is said, hey, we're going to revise this automatic telephone dialing and announcing device, and here's our new definition. And guess what? That definition just have to almost perfectly track the Marks decision from the Ninth Circuit's interpretation of what is an auto dialer that is prohibited, at least under state law. If that came out, luckily that bill was killed pretty quickly. Is it going to be resuscitated in some way? We just pray not. But it's going to be foolish to think that there are other states' attorney generals, other state legislatures that are not going to think about what do we do to prohibit mass calling to our consumers, our constituencies. And this is an issue that is not a Republican, it's not Democrat. This is an issue that crosses all party lines. I don't know of a person who says, oh my God, I got 20 calls today and 18 of them were just those, quote, robocalls, calls I didn't want, calls I didn't expect. I don't know how this company even got my number in the first place. Are they coming from overseas? So this is still a huge problem. Yes, with yesterday's decision, there's a good chance that there could be a flurry and flood of calls because all these companies are going to say, I'm not using an automatic telephone dialing system. And they may just, quote, skirt whatever, let's say, laws may be in place. But we have to be, it's naive to think that there's not going to be a flurry of activity in various state legislatures. I'm already hearing that in Connecticut, that is an issue. In New York, they're looking to expand, I think, their recent telemarketing auto dialer law. So I think New York is already on the verge of working through that. So I think that is very important. So look, there's so many things and there's so many issues that I could have brought up today, so many things I wanted to talk to you about that unfortunately due to time constraints, we didn't have. I know that some of you have, so many great questions, and they're great questions. I just again would caution that this is not the time to throw caution to the wind and start throwing out all of your compliance protocols and say, "Hooray, it's over."
Like the last day of school.
Exactly. And this is not just that run out of school or that get out of jail free card where you're just running completely abandoned and unrestricted. We have so many other laws that are restraints. The CFPB, Reg F will be in full force in effect in some form in November. We have the 7, 7, and 7 rule with regard to what the CFPB is saying must be your limited calling strategy. So that is something that you need to be seriously thinking about. So this is not just let that baby rip. That is not what I want you to be taking away from this. I think what I want you to say is, I've got some great protocols in place. It's doing well for me. Maybe I can relax certain things, but maybe I can't relax certain things. And guess what? If there's some other draconian laws that come into play, if Congress quickly moves and revises that law, and comes up with something that is even more restrictive than what even Marx had come up with in its auto dialer interpretation. Am I already prepared for that? Because I've already had these compliance protocols in place and I know what to do with them, and I'm not starting from scratch and I haven't thrown everything out the window. So I'm just saying, just tread with caution. Look at what you do, how you do it. Talk to your in-house compliance professionals that are in-house. Talk to your IT people, talk to your telephony people, talk to your outside counsel, and look at what your company does and how it does it, and what is the best way to proceed going forward. I would just say proceed with caution. And remember, I don't know what kind of dialing system you're using, but just don't think that human intervention is, quote, a free get out of jail pass. As well as I said earlier, the Supreme Court has already said that they don't even know what that human intervention means, and they're not buying into it, and it's not an issue that is an out for using prohibited telephony under the TCPA. So remember, capacity is still an issue. I wouldn't be surprised if plaintiffs in a current TCPA action that you have, whether it's individual or class, seeks to take the deposition of your person most knowledgeable as to your telephony, to try to drill down as hard as they can to determine whether in fact you're using an auto dialer. Yes, they may be going down a rabbit hole. Yes, it may be expensive for them to do it. Again, some have the wherewithal and will push the envelope. So you have to be ready and prepared to defend with that. I have countless TCPA class actions right now that I'm defending throughout the United States. Many of them have are a mixture of, let's say, auto dialer issues and pre-recorded message issues. So in that regard, some of the plaintiffs' attorneys don't believe that they have a great concern, because they will still push the pre-recorded message angle. So a lot to think about. Mike, I take it that I'm at the end of my rope here. And
well, you're not at the end of your rope, just at the end of your time. So I apologize. I hate to cut you off, but we've got another webinar coming up in 10 minutes, actually. So if you haven't registered for that one, I just put a link in the chat box. David mentioned the call frequency caps under Regulation F. We're going to be talking a little bit about that coming up at 1 o'clock Eastern. So if you haven't signed up for that, sign up for that. But David, thank you so much for sitting down and starting to break this down for us today. A ton of great information, great insights. Really appreciate you. Sort of on behalf of everybody watching and listening, this was great. Thank you very much.
Thank you very much, Accounts Recovery. Thank you, TCN. And look, there's much more to come, and we'll be doing other sessions for you, which will hopefully answer the rest of the questions that you have that we didn't even get to, and the rest of the things that I wanted to talk to you about. So thank you so much for the opportunity. God bless everybody. Happy Easter, happy Passover, and whatever you celebrate, be well.
Thank you. And thanks again, David. Thank you again to TCN, like David said, for sponsoring today's webinar. Go to www.tcn.com to learn more. There's a link that should pop up on your screen, or a website that should pop up on your screen to share your feedback about today's event. Share any other ideas you've got for webinars you'd like to see covered in the coming days, weeks, and months. So be sure to send that over, because it's really helpful to me. As David mentioned, if I'm not going to see you in a few minutes for our next webinar, have a great weekend. Have a great Easter. We'll see everybody next week. So thank you again. We'll talk to you soon.
Thank you. Bye-bye.